Okay. Can this be okay? We want to do this share all of us for refuah for all the cholim of Yechad Klal Yisrael. And there was an attack yesterday, I think in the Shomron, and there was a guy and his two daughters were attacked. And he went to hospital. I haven't heard anything, so I assume he's recovering. But refer flame to him and to others.
Amen.
So one thing, I just had a thought like less than 5 minutes ago, what I wanted to say. So the Exodus from Egypt is very central to our faith. You in the Shema, in the Shema it talks about when you have your tefillin, with an outstretched arm, that's where you put the tefillin on your arm, and then many other instances where it refers to the Exodus. And the one thing about Egypt is we have to escape from our personal Egypts, which is our limitations. That's a lifetime's work. And I think the Jews were, well, they were the Jewish people. They had to get out of that consciousness, out of that restrictive life. Otherwise, they wouldn't have been able to move to get to Israel and populate the land. So they had to escape from that restrictive, negative place in order to find redemption.
Wow.
And then settle in Israel, the land.
Okay. Is that a hint, Kev?
No, I'm just talking. No,
I'm just
escaping like Egypt's whatever,
no, it's
how
true.
one can interpret
We've
it.
all got and in
We
the
all
Egypt
have.
to master. I agree. I agree with you. All right. Cool. Art, we'll chat afterwards. With pleasure. Kevin, what did Stephen Noack say in the end?
I've got these books here. I've picked them up today. Actually, it's quite amazing. That guy lives like 2 minutes walk away from here. And it came from a special printer in Jerusalem. No, it's fine. I've got them with me.
All right. So yeah, we'll just discuss afterwards what's going to be not burdensome for you. All right. So
Yeah, I'm gonna.
we're 108 B2. I'll give you a call, Kevin. I was sleeping. I'm so sorry I didn't answer your call. So we're discussing in the Gemara the inverse of the previous case. So let me just lay out what the inverse would be. Is, guys, you've got to consider a case where the owner of a deposit that had been stolen sued the custodian for its return, and the custodian paid to him for it instead of exempting himself through an oath. Okay? So, therefore, the custodian thereby acquired the rights to the kefil payment, as we learned in Bava Kamma 33b. Now, the thief afterwards was subsequently identified. The owner, though he had already been paid, sued the thief for return of the theft, and the thief admitted to having stolen it. Then the custodian sued the thief, and he denied having stolen it. So he admitted it to the actual owner, who'd already been paid by the custodian, and then the thief denied it to the custodian. Now, you must realize that the custodian has the interest here, technically, not the original owner. Why? Because the custodian got paid. I mean, the original owner got paid by the custodian. So technically, he's not really even an interested party. Got financially sorted out. So it's a problem that the thief never admitted it to the custodian, because he's the person that's actually owed the money at this point. So the custodian extended himself and paid irrespective. Now, eventually, the custodian brought witnesses who testified that the thief had in fact stolen it. So the thief confessed to the owner who had already been paid, but not to the custodian who is actually entitled to the kefil payment, because he didn't even have an oath and then afterwards paid. So according to all opinions, according to Abaya, according to Rava, according to every opinion, Bava Kamma, there's not a question that since he never exerted the courts nor irritated the original owner and just paid even though he didn't have to, he is absolutely entitled to the kefil payment without a doubt. Okay. Now, we want to know that when witnesses later attest to the guilt of the thief, what's the law? Is the thief exempted from paying the kefil penalty by virtue of his confession to the owner or not? So what are we saying? In this case, the custodian is considered the plaintiff. Why, guys? Because if the thief would admit it to him, he would be exempt from the kefil penalty, because the only financially interested party now is the custodian, since he already paid his money forward to the original owner, and therefore he's considered the plaintiff. Now, if the thief, without having witnesses, admits liability to the interested party, financially the one that is owed, then the thief would be exempt from the kefil payment, and he'd only have to pay the principal back to the plaintiff, which in this case is the custodian. So it's exactly the same case as before, except we're switching custodian and thief in terms of who got paid and who was admitted by the respective thief. So the question is whether or not the owner retains his status as a litigant regarding kefil or not. Now, if he does retain his status as a litigant and the thief admitted it to him, to the original owner, then that's great for the custodian. Why is it good for the custodian? Because he actually only had to pay the principal. He didn't even have to pay the principal back, but he did. But now he earns double because the thief confessed to the original owner. And we learned that if you confess to a party that isn't financially, involved in the process, then the kefil payment still remains for the thief if witnesses come against him. Do you get what I'm saying technically? Because he didn't admit it to the right party. So that would be the best thing for the custodian. In the reverse case, we learned that the reason that the custodian, even if he paid, could still be an interested party is because he's an interested party for the original owner. Because if the original owner is in Australia and the thief got caught, but the custodian was honest about the oath and never swore falsely, there's no doubt that, especially if the original owner was paid by the custodian, that he trusts the custodian to receive the money from the thief. The fact of it is he should be paid back, but it depends if you're holding by Rav and a buyer. So the question is whether or not the owner retains his legal status as a litigant regarding the kefil payment or not. Okay. Now I'm sure you guys are following. I hope so. So basically the Gemara says, do we say that the custodian can say to the owner, since you took payment for the deposit, you are removed from here, and the thief's confession to you has no validity. So when the owner accepts payment from the custodian, who could have exempted himself through an oath, he conveys to the custodian not only his rights to a future kefil payment, but even his right to regain the animal itself. If the animal is eventually recovered from the thief, the custodian may keep it. So we're saying if there's a kefil, he gives the animal back, and he obviously would give the penalty on top of that. So the owner is completely removed from the scene at the point where the custodian paid him, and an admission to him ought not to exempt the thief from paying kefil to the custodian. Because if the thief admitted it to the original owner, it's like admitting it to any other party, with the exception of the plaintiff, who has no financial interest and therefore doesn't exempt the thief from paying kefil to the custodian, which is a win for the custodian for sure. Okay? And we can understand why the custodian would speak to the original owner like that. Or perhaps the owners can say to the custodian, just as you did something for us that was not required of you by voluntarily paying a deposit, so too courtesy demands that we do a similar favor for you. Accordingly, we will trouble ourselves to go after the thief and exact payment from him. So just as we have received from you what is ours, in other words, payment for our animal, you will receive from us what is yours, a refund of your payment. And since the owner has an interest in the case, he's considered a litigant, so the thief's confession to him serves to exempt him from paying kefil to the custodian. Okay? So the Gemara offers no solution and concludes, let it stand unresolved. So do you guys understand the principle there or not? Right? Do you understand it?
Yeah, I kind of understand. Like, it's the different what we did yesterday. Is basically the guy who had his stuff stolen now wants to take back, pay the guy that paid him the money, through a confession, and he wants to claim everything back a double payment. That's what it's sounding like.
Say that again.
Okay, so John Yaakov has a custodian called Michael. Okay.
Yeah.
And Michael, something happens, and Michael says, "Okay, fine. I didn't steal. I'm not going to take oath, but I'm going to pay you for what was stolen."
Yeah.
Now they found the criminal. Okay. Now what he's saying is, Jacob says to Michael, "I'll give you your money back, and it'll become my problem." To get so it's kind of like he wants to get it, like the guy that wants to get the double, almost like a double penalty
he can't get the double penalty. That's why it's excellent you raised it. The reason why is the minute he says, "Don't worry, I'll pay you," the minute I get hold of the thief, I'll pay you your share back. He's an interested financial party, right?
Yeah.
So, and that's why he's prevented from getting the kefil, because the thief already confessed to him. That's what makes him not pay the kefil. So there's no reason for the original owner to get involved, because he doesn't make any profit from it. Do you get what I'm saying? You would only be right in a case where witnesses come against the thief. Say the thief hadn't confessed at all. Then the original owner might be able to say that, because he gets the kefil as an interested party if the thief hasn't admitted to the original owner what he did. Then the kefil comes back to him, and he could say, no, don't worry, I'll give you your share back. I'll do you the courtesy. You extended yourself. I'm this big tzaddik. I'll give you back what you owe, what you owed, and I get to keep the double. That's not a tzaddik. That guy's a scheming, shocking person. So we're saying that in a case where witnesses come against him, the thief, the original owner stands to make back, even after he's paid the custodian, at least what was stolen from him as profit. So that's why in Bava Kamma, with that particular case, it doesn't exist like that, because all he can do is, especially if there was no false oath on behalf of the custodian, he's kind of out of the picture. It's not an avenue for him to make profit. The only difference between a buyer and Rava is a buyer says when the case gets a bit mixed up, where there's an oath that's taken, then the custodian forfeits that right to get payment back, even if he confesses afterwards, because he aggravated the court, the original owner, and he wanted to clear his name, then worry about using Hashem's name. According to Rava said, what are you talking about? He might have aggravated this guy, but maybe he wanted to just clear his name. And as long as he paid when he didn't have to, that's good enough. That's good enough. So here you're right, that the original owner stands to earn twice instead of just being paid once. So when he magnanimously says to the custodian, here, I'll give you your money back, I'm such a tzaddik, I'll repay the courtesy, he wants to get twice. So we're saying if there are witnesses that come against the thief and there was no confession made, well, that's a no-brainer. But that's a no-brainer to a certain extent. But here, the thief did confess to the original owner, and since he had an interest financially, because he would have sued for twice if he could have, he is considered maybe an interested party. So all we say is not an interested party because he got paid out. And the Gemara says, well, we don't know at the end of the day. It stands unresolved because you could look at it both ways. All right, let's get on the new part. So the Gemara discusses a custodian's responsibility to pursue a thief and retrieve the deposit that was stolen from his custody. Okay, I'm going to repeat it because I think I lost you guys. Have you still?
I heard you. Why does he have that? I don't understand why the custodian has that responsibility though.
Okay, I'll tell you why.
Is he paid or unpaid, this custodian? It doesn't matter.
Well, that's exactly the point. You hit on the answer.
Okay.
Because a paid custodian has far more obligations than an unpaid. And he's responsible for far more. So with regards to the custodian's responsibility to pursue a thief and retrieve the deposit that was stolen from his custody, the Gemara states it was stated with respect to a case where a deposit was stolen from custodian in an unavoidable way. So what we mean by that, Gavin, is it was stolen by armed bandits. So that constitutes an honest and unavoidable mishap. For even a paid custodian is exempt. So we're saying, well, if that's the case, then why is there further responsibility if we can't hold the custodian responsible? Okay. And I think the point is here is that the custodian, even if he's exonerated and not made responsible, he should still do everything in his power to try and work within the process to make sure the original owner is looked after. And I think that's why they choose this case of an unavoidable way. Do you get what I'm saying? Gav?
Yeah, I can hear you.
So we're saying that even a case of a paid custodian that's responsible for far more, if it's stolen in an unavoidable way, then where he could be off the hook, he still has to take some responsibility for trying to pursue the thief. Anyway, we say the thief was subsequently identified, so the custodian now has the ability to retrieve the deposit from him. So according to a buyer, if he's an unpaid custodian, then if he wants, he can settle with the owner and sue the thief himself, or if he wants, he can swear and be absolved of all responsibility. So, what does that actually mean? Well, it means the following: is that he's not obligated to deal with the thief, Gavin. Rather, if he's so inclined, he can pay the owner for the loss of his deposit and then sue the thief. That's one way. Or if he prefers, he can remove himself from the picture by swearing that the deposit was stolen and actually leave the burden of dealing with the thief to the owner. Okay? If the thief is identified by witnesses who testified that he stole the deposit, the custodian obviously wouldn't have to swear that it was stolen. That's a given. So, according to the Beis Yosef, in such a case, he'd also be exempt from the oath because he wasn't negligent. He didn't misappropriate the deposit. You can see from witnesses he was telling the truth. It doesn't have to be an official declaration with Hashem's name. Anyway, accordingly, we've got to explain the Gemara here is dealing with a case where the thief was apprehended by witnesses who testified that the deposit is in his possession, but they don't even know that he actually stole it at this stage. Anyway, it depends what the custodian wants to do in terms of level of responsibility. This is for an unpaid custodian. But to reach Gavin's point, which was quite insightful, that he knew what that we are talking about different issues here in terms of paid or unpaid. a paid custodian, Gavin, must settle with the owner and can't swear to absolve himself. Why? Because you think, hang on, but it's an honest, it's an unavoidable mishap. Why can't he? So although the custodian that's paid is not liable to absolve the loss in the case of unavoidable theft, in the case where the thief has actually been identified and the custodian will not lose monetarily, it's his duty to go through the trouble of retrieving the deposit for the owner. Therefore, he must pay the owner and litigate with the thief himself. That's according to Rashi. Since he has the ability to recover the deposit for the owner, he no longer has the exemption afforded by the previously unavoidable mishap. Why, Gavin? Because at that point they found the thief before he took an oath. So he has got ability to recover his money. So his duty as a paid custodian is that in this situation, it requires him to rectify the issue if a thief becomes available. That's what we say, Gav. Okay. But so that's according to Abaya. Now, Rava has a completely different opinion. Both the paid custodian and the unpaid custodian must settle with the owner and cannot swear to absolve himself from liability. Okay, so I'm just going to explain what that means. Is that even the unpaid custodian must pay the owner and then litigate with the thief, for it's a mitzvah upon him to pursue the lost deposit and return it to its owner, since he undertook to safeguard it. So that's according to Rava. Okay, but there are different opinions. Rashba and other Rishonim don't exactly agree with this explanation of Rava by Rashi. So granted that according to Rava, even the unpaid custodian is obligated to go through the trouble of pursuing the thief. There's no reason why he should have to pay the owner before he wins the case, according to the Rashba. Now, guys, that makes sense. And is paid by the thief. In other words, he's got to pursue him legally, but only when he gets paid by the thief that he must immediately settle with the original owner, but not at the point before he gets the money. Does that make sense, guys? So therefore, a buyer maintains that an unpaid custodian has the choice here, can sue the thief for recovery of the stolen deposit or exempt himself with an oath. Whereas a paid custodian hasn't got any choice, but he has to assume the burden of suing the thief. So Rava maintains that even an unpaid custodian is bound to assume this burden. In any event, Rashi's explanation is that paid or unpaid, the original owner gets paid if a thief appears on the scene, and then it's their job to get it back. According to the Rashba's opinion of Rava, he has to take on the suing process, but he doesn't have to pay until he gets settled. In any event, that's the view that's held by the Rambam also, and he determines halacha that the custodian is not required to pay the owner anything before he wins the case, but he has to basically pursue it from a legal perspective. Now, it makes sense. Now, it makes sense, the second opinion of Rava, because we learned before, who was more lenient, guys, Rava or Baya, with regards to custodian that swore and then decided to pay in advance when he didn't have to? Who was more lenient? Rava was more lenient, guys, because he said that the person did end up paying. So even if he took a false oath, he still paid when he didn't have to, and he could have gotten out of it. Whereas the buyer said, no, he created aggravation to the court and the original owner. If he paid afterwards, it's his tough luck. He's not going to get reimbursed. So therefore, it seemed initially when we looked at this that Rava was more stringent, that the paid and unpaid custodian had to settle with the owner and couldn't swear to absolve himself of liability. So in this case, it seems that Rava is more stringent than a buyer, who says that basically the unpaid custodian can either take an oath to get out of it or pay the original owner if the thief rocks up on the scene and sue. So in this case, a buyer seems more lenient. But if we want to look at how the Rambam explains Rava, he's saying no, they both have to take up legal calls, but no payment is to go to the original owner until the custodian gets paid, and then he can transfer the money. So does that make sense, the Rambam's opinion? To me, it does, because it shows a consistency of Rava being lenient in both cases. Not more lenient in the buy and the second, but certainly not having to full pay. So the Gemara looks at
makes a lot of sense.
yeah, Rava's opinion. So it says, shall we say that Rava disagrees with the opinion of Rav Huna bar Avin? Rav Huna bar Avin sent the following ruling. If a deposit was stolen from a custodian in an unavoidable way, and the thief was subsequently identified, the law is as follows. If he's an unpaid custodian, guys, then if he wants to settle with the owner and sue the thief himself, or if he wants, he can swear and be absolved of all responsibility. But if he's a paid custodian, he must settle with the owner and cannot swear to absolve himself. Okay, so all it's doing there is that seems to be identical with the opinion of a buyer, and not that of Rava. Seems like a mirror image copy, which means somebody as great as Rav Huna bar Avin is agreeing with the buyer. So the Gemara says, well, how would Rava respond to that? And Rava is going to say, listen, we're dealing with a case here in which Rav Huna bar Avin's ruling is where the custodian actually swore before the thief was identified, meaning that at the time that he swore, he had no obligation to pursue the thief. He already exonerated himself by not paying because he took an oath. So if he was an unpaid custodian, the oath terminated his custodianship and absolved him of any further financial responsibility because he abdicated from it just with the oath, and he's entitled to. If he was a paid custodian, he's liable to sue the thief, even if he identified, even if a thief was identified like after the oath is taken, guys, because his custodial duties include the responsibility to search for a deposit, even if it was stolen in an unavoidable manner, like he was robbed at gunpoint, right? And this duty is not terminated by the oath. So, even though the paid custodian isn't financially responsible for an armed robbery, and the oath can get him out of payment, then for sure, it doesn't mean he's off the hook in terms of effort, though, if he's a paid custodian. He has to do everything he can to retrieve it, just because he was off the hook. So if the thief is discovered before the custodian swears, then even the unpaid custodian, according to this defense by Rava, is obligated to pursue the thief in court and retrieve his deposit. So they both saying it doesn't make any difference if he's paid or unpaid, according to Rava. In this case, it depends where the thief has appeared on the scene, before the oath or after the oath. But the Gemara is not sure if this interpretation is what you call subjective. But Rav Huna bar Avin said if he wants, he can settle with the owner and sue the thief himself. Or if he wants, he can swear and be absolved of all responsibility. So, guys, this wording indicates that Rav Huna bar Avin is dealing with a case where the custodian didn't yet take an oath. This was before. It's saying because he can either choose to take an oath or settle the owner. This is not at the point at which the oath was taken and the thief rocked up on the scene. So the Gemara answers, this is what Rav Huna bar Avin meant to say. If an unpaid custodian swore and the thief was then identified after the oath, guys, then the unpaid custodian wants, he can stand by his oath and remain absolved of all responsibility, or if he wants, he can settle with the owner and sue the thief himself. So the way this is explained afterwards is after he's taken the oath and the thief appears on the scene, he can either stand by his oath or take a high level of responsibility, but it's up to him. So Abaye and Rava agreed that at least a paid custodian is required to pursue the thief and retrieve the deposit, if possible. So even when the custodian is exempt from paying, his duties aren't terminated by the theft just because he's off the hook financially. He's got an obligation to put in effort. There's a dissenting view. Okay. Let me just see how much time we've got left. We've got time. and then we're done, guys. So what's this view? Rabbi Zuti inquired about this law as follows: if the deposit was stolen in an unavoidable way, and the custodian was exempt from paying for loss, even if he had been paid for his services. So with a paid custodian, say it was an armed robbery, and the thief then returned to the custodian's house. And in other words, what happened is the thief realized there were suddenly witnesses against him, and what he wanted to do is kind of label it on the thief. Sorry, the thief wanted to label it on the custodian, or at the very least, return the animal to the custodian's house, because he felt like paying careful like a hole in the head, and he assumed there were witnesses against him. Now, what happens if it returned to the custodian's house and it died through the custodian's negligence? So the reason he spoke to the custodian is he said, listen, I'm returning the animal to you. I see the witnesses that might come against me. I'm not sure, but I'm confessing it to you and returning the animal. So you're only getting back what I stole, but you're not actually getting a double payment from me. I can't afford it. So here's the animal back. But the animal subsequently died because the custodian didn't feed or look after it at all. Now, even the custodian is off the hook because he took an oath and it was stolen from him. The question is there room to hold the custodian liable even if he was like not being paid for his services, an unpaid custodian? So in short, guys, the inquiry pertains to both a paid custodian and an unpaid custodian, with the example of an armed robbery, because even a paid custodian is not responsible. So we're saying, does he assume a responsibility again when the animal is returned to him, and therefore if it dies through the custodian's negligence, can be sued? So, or do we say that once it was stolen in an unavoidable way, the custodian remains exempt and his custodianship was terminated and doesn't resume any responsibility? So we're not sure. And the Gemara says, let it remain unresolved. We don't know. All right, guys. We've got 6 minutes to Rav Simcha. I'm personally wrecked. I'll chat to Arthur on the phone, and Arthur will chat to Kabb.